Hello, I'm John Ainsworth, and I got a little story to tell you. I went to a couple of friends of mine, and I went to the North Carolina General Assembly in Raleigh, and there was a meeting there for the North Carolina Institute on Constitutional Law. They made a presentation on how to amend the Constitution. We had a Chief Justice there, or excuse me, a former North Carolina Supreme Court Justice. Let me try to get these names right. Robert Orr was there. We had John Orth, who is a University of North Carolina law professor, and the only other person that put input in was an individual by the name of Jerry Cohen, who is the director of legislative drafting for the North Carolina General Assembly, and was a former attorney for the North Carolina General Assembly. The topic there was how to amend the Constitution of North Carolina, and we sat through this for about an hour, and I decided to ask a question because we're talking about amending the Constitution of North Carolina today. And of course my issue is that the original North Carolina Constitution was never changed by the consent of the free people of North Carolina through the Reconstruction Act. And so I posed the question. I'm not sure how good the quality of the sound and video is that you're about to see after this, but I posed the question of, are we getting a cart before the horse, deciding how to amend this Constitution when it's still kind of an unsettled issue of whether the Constitution of 1868 and the process that put it into place was lawful and constitutional, followed due process, didn't violate any aspect of the Constitution, and it was of the consent of the free people of North Carolina. Not just any people in North Carolina, not the people that Congress choose, but the free people, the people of the posterity that's in the Constitution. And so you can see the bantering that goes back and forth with that. And I know this is an issue that is, it's hot and it's not easily resolved. But my fundamental issue with this is the courts in North Carolina the place to resolve this. If the state in operation today cannot prove it's lawfully created, which is the foundation of all jurisdictions, can they demand obedience from all the people of North Carolina? Again, if they cannot prove it, if they refuse to prove it. And we got involved in this topic for, I don't know, maybe 5 minutes. We were going in it, and John Hood of the John Locke Foundation, I didn't know who it was at the beginning, raised his hand at the back, and Justice Orr said, oh, well, he'll open the floor to John Hood to put his input into this topic. And John Hood said, well, he didn't really want to put input into this topic. He was raising a new topic, which basically he was deflecting the conversation. And I approached John Hood afterwards, and I found it very, I didn't know, again, I did not have a clue he was with the John Locke Foundation. Actually one of the founders of the John Locke Foundation. And I approached him afterwards to talk a little bit about this. And he basically said that it's to follow it into the courts, to try to go into the courts, to settle the issue of the lawful jurisdiction of North Carolina is an absolute waste of time, and that is not the place to do it. And of course my position is, so you're saying that if an unlawful entity comes into place, there is no remedy? There is no remedy in law. So there's a little bit of a conflict there. I think John may have been caught a little bit off guard, but I'd like to challenge John to a debate on this, on what are the people's rights, and at what point does an unconstitutional act becomes legitimized. These are issues I'd like to bring forward, get some open debate on it. The issue is the American people need to know what happened to our government, how we got here, and look at some other directions to look at as far as what's the remedy. And we cannot have lawful remedy if we do not know what happened. And this is a part of our history that's under a dark cloud. And there's no eagerness to remove this dark cloud. And that's what we're about. Let's remove the dark cloud. Let's bring truth and honesty, integrity. Let's bring law back to America, because I believe that we should be a nation of laws, not a nation of men. And when men can overthrow the Constitution, overthrow laws, and then they use the law to protect themselves, that's a nation of men, not a nation of laws. But if you want to contact me, feel free to look up my website at americasremedy.com. Go to our other website of ncrepublic.org. Feel free to contact me. I'd love to spread this information. Yes, sir. is there a certain degree of putting the cart before the horse here? In that, you know, we speak fluidly going from the 1776 Constitution, the proposed Constitution of 66, to the Constitution of 1868, and the process that took place which established this new state that entered the Union in 1868. A due process of law following that process in 1867 with the Reconstruction Acts. In other words, is the state that's in place now can't take a legal challenge as to the due process of law and the constitutionality of its foundation. And we're talking about amending this new Constitution, but I'm talking about, are we getting the cart before the horse by not addressing the constitutionality of the Constitution and the due process that put it into place, or the violations?
The Confederation didn't provide for having a constitutional convention to write the U.S. Constitution, so I suppose the same issue could say that, well, are we actually still under the Articles of Confederation because there was no authority to have a U.S. Constitutional Convention in 1787?
Okay, well, but again, we didn't switch from one government to the other. That was Article 7 of the Constitution, said that each state set up a convention, and they chose to either secede from the Articles of Confederation. As you know, North Carolina, when the United States was established in November, well, in 1788, North Carolina was not part of the United States. We didn't come until November 21st, 1789. So we were out of the Union. We had not chosen to leave the Articles, but once we adopted the Constitution, we had chosen as a people the political rights are vested in to go under the Constitution. So the Articles get left behind us.
In a philosophical sense, I think one could say that the people have the right to establish their own government, and a legislature, a constitution which has a very restrictive right to amend it, that if the people have a convention and approve a new constitution, whether or not it complied with the provisions of amending the old one, I think you could argue the sort of fundamental right of humanity is the right to form its own state, and that it can't be bound by some prior thing. And that's sort of history in Rhode Island in the 1830s, where they had no provision for amending it. There was nearly a revolution in Rhode Island.
Luther versus Borden?
Forcing through a new constitution.
But the Supreme Court ruled on that,
yes,
basically saying that the Congress had to recognize the charter constitution that came in from the king, and they didn't have any right to rule any otherwise. But I'm talking about in North Carolina, you know, are you arguing that it was a lawful constitutional process, Reconstruction was a lawful constitutional process?
Well, whether it was, I mean, in 1969, the legislature approved a new constitutional rewrite, which was approved by the provisions for in the 1870 Constitution, in which the voters approved a new constitution. So I would say that if there was a problem from 1868 or 75, that was cured in 1970 would be my answer.
I would tend to disagree, because a state, as we all know, is comprised of three components, one of which is the body politic, two is the Constitution, and three is the territory, the soil. The body politic was changed, so we did get a new Constitution over the same soil, but the body politic was nationalized through the coerced amending of the 14th Amendment, which was in Article 5 of the Reconstruction Acts. So we've got coercion, you've got bills of attainder. You have a clear bill of attainder in 1867. Because I'm bringing these into court. I'm fighting these in court because I don't really recognize this state as having a lawful foundation. And we're doing what we consider to be the lawful thing, is challenge it in court. We're having huge difficulties having the court want to discuss this. And, and I find it very, very strange that a state, when challenged to prove that it's a lawfully created state, refuses to do that, because that's the foundation of all law. Is a lawfully constituted jurisdiction, and if we can't get that jurisdiction set and proved lawful, then does that bind the people to actually obey it? Are they required to obey a government that will not prove its lawfulness? Because that's a huge issue, and Professor here is talking about one of the problems we have is not having an educated populace. And I don't see where this is actually dealt with in our public education system. I don't see where it's dealt with in our legislative parts or in the courtrooms. The courtrooms have actually gone the other way. Yes, sir.
I would say, despite Article 13's detailed provisions of how to amend it, in our State Bill of Rights, Section 3, the people of this state have the inherent, sole, and exclusive right of regulating the internal government and police thereof, and of altering or abolishing their constitution or form of government whenever it may be necessary to their safety and happiness. But every such right shall be exercised in pursuance of law consistently with the Constitution of the U.S. It sort of regulates the fundamental right of the people to organize their...
No, I agree with that. The issue is who were the people. The people originally in the original Constitution was the freedmen of North Carolina. Congress made it the United States citizens residing in North Carolina, changed the body politic. And so the issue gets to be the Constitution of the United States, if you read the preamble, was ordained for ourselves and our posterity. Was it the posterity, were they the people that made that Constitution of 1868? I would dare say not. I would say the Reconstruction Acts had a bill of attainder.
Get Mr. Hood.
John Hood will resolve this.
Yes.
Have him come up.
Recognizing that we have other things happening later in the day here in the building, different things people need to get to, I wanted to ask a question related to Professor Orth's point about why you might want to avoid frequent amendments so as to make the Constitution more like a set of constantly changing laws rather than a set of procedures